All right, so now today we're going to study in detail about the governor. So, the Constitution of India envisages the same pattern of government in the state as that of the center, that is, the parliamentarian system. Part 6 of the Constitution deals with the government in the states. Part 6 of the Constitution deals with the government in the states, and Article 153 to Article 167 in the Part 6 of the Constitution deals with the state executives. The state executive consists of the governor, the chief minister, the council of ministers, the advocate general of state. So these are the chief minister, the council of ministers, and the advocate general of states. Thus, there is no office of vice governor in the state like that of the vice president at the center. Governor is the chief executive head of the state, but like the president, he is a nominal executive head, tutelar or constitutional head. The governor also acts as an agent of the central government. Therefore, the office of governor has a dual role. Usually, there is a governor of each state, but the 7th Constitutional Amendment Act of 1956 facilitated the appointment of the same person as a governor for 2 or more states. Here, now, the appointment of the governor. Let's see how the governor is appointed. Let's see the process of appointment. So, the governor is neither directly elected by the people nor indirectly elected by this specially constituted electoral college, as in the case with the president. He is appointed by the president by warrant under his hand and seal. In a way, he is a nominee of the central government, but as held by the Supreme Court in 1979, the office of governor of a state is not an employment under the central government. It is an independent constitutional office and is not under the control of the subordinate to the central government. The draft constitution provided for the direct elections of the governor on the basis of the universal adult suffrage, but the Constituent Assembly opted for the present system of appointment of the governor by the president because of the following reasons, very important. Number 1, the direct election of the governor is incompatible with the parliamentary system established in the states. Number 2, the mode of direct election is more likely to create conflicts between the governor and the chief minister. Third, the governor being only a constitutional head, there is no point in making elaborate arrangements for his elections and spending huge amount of money. Next, the elections of a governor would be directly on personal issues. Hence, it is not in the national interest to involve a large number of voters in such an election. Next, an elected governor would naturally belong to a party and would not be a neutral person and an impartial head. Next, the election of governor would create separatist tendencies and thus affect the political stability and unity of country. Next, the system of presidential nominations enables the center to maintain its control over the state. The direct elections of the governor creates a serious problems of leadership at the time of general election in the state. Next, the chief minister would like his nominee to contest for governorship. Hence, a second-rate man of the ruling party is elected as a governor. Therefore, our American model, where the governor of a state is directly elected, was dropped, and the Canadian model, where the governor of the province or the state is appointed by the governor general, that is center, was accepted in the Constituent Assembly. So, the Constitution lays down only 2 qualifications for the appointment of a person as a governor. These are, he should be the citizen of India, and second, he should have completed the age of 35 years. Additionally, 2 conventions have also developed in this regard over the years. First, he should be an outsider, that is, he should not belong to a state where he is appointed, so that he is free from the local politics. Second, while appointing the governor, the president is required to consult the chief minister of the state concerned so that the smooth functioning of the constitutional machinery in the state is ensured. However, both the conventions have been violated in some of the cases. Now let's see the conditions of the governor's office. Constitution lays down the following conditions for the governor's office. Number one, he should not be a member of either house of the parliament or the house of the state legislature. If any such person is appointed as governor, he is deemed to have vacated his seat in that house on the date on which he enters upon his office as a governor. He should not hold any other office of profit. Next, he is entitled without payment of rent to use of his official residence, that is Raj Bhavan. He is entitled to such emoluments, allowances and privileges as may be determined by the parliament. Next, when the same person is appointed as the governor of two or more states, the emoluments and allowances payable to him are shared by the state in such proportion as determined by the president. Next is emoluments and allowances cannot be diminished during his term of office. In 2018, Parliament has increased the salary of the governor from 1.1 lakh to 3.5 lakh per month. Before entering upon his office, the governor has to make and subscribe to an oath of office. In his oath, the governor swears to faithfully execute the office, to preserve, protect and defend the constitution and the law. Next, to devote himself to the service and the well-being of the people of the state. The oath of the office to the governor is administered by the Chief Justice of the concerned State High Court, and in his absence, the senior-most judge of that court is a court if available. Every person discharging the functions of a governor also undertakes the similar oath of office. Now let's see the terms of the governor's office, right? So a governor holds office for the term of 5 years from the date on which he enters upon his office. So, however, this term of 5 years is subjected to the pleasure of the president. Further, he can resign at any time by addressing a resignation to the president. Supreme Court held that the pleasure of the president is not justifiable. Means it cannot be questioned. The pleasure of the president for the appointment of the governor cannot be questioned at the court. The governor has no security of tenure and no fixed term of office. He may be removed by the president at any time. Constitution does not lay down any ground upon which a governor may be removed by the president. Hence, the National Front government headed by VP Singh in 1989 asked all the governors to resign as they were appointed by the Congress government. Eventually, some of the governors were replaced and some were allowed to continue. Same things was repeated in 1991 when the Congress government headed by P.V. Narasimha Rao changed 14 governors appointed by VP Singh and Chandrasekhar governments. The president may transfer. The main important is that the president may transfer a governor appointed to one state to another state for the rest of the term. Further, governor whose term has expired may be reappointed in the same state or to the other state. The governor can hold office beyond his term of 5 years until his successor assumes the charges. The underlying idea is that there must be a governor in the state and there cannot be an interregnum. President can make such provisions and as he thinks fit for the discharge of the function of the governor in any contingency not provided for in the constitution. For example, the death of the sitting governor. Thus, Chief Justice of the concerned State High Court may be appointed temporarily to discharge the functions of the governor of the state in such cases. Now, the powers and the functions of the governors we'll see. A governor possesses executive, legislative, financial and judiciary powers, more or less analogous to the President of India. However, he has no diplomatic, military or emergency powers like the President. So as I said, the power and the functions of the governor can be studied under the following heads. Those are executive, legislative, financial and judicial. Right, so let's discuss the powers under the head of executive powers. So what are the executive powers? enjoyed by the governor. The executive powers and the functions of the governor are: number one, all executive actions of the government of the state are formally taken in his name. Number one. Number two, he can make rules specifying the manner in which the order and the other instruments are made and executed in his name shall be authenticated. He can make rules for more convenient transactions of the business of the state government and for the allocations among the ministers of said business. Next, he appoints the chief minister and other ministers. He also holds office during his pleasure. There should be a tribal welfare minister in the state of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha appointed by him. The state of Bihar was excluded from this provision by 94th Amendment Act of 2006. Next, he appoints the Advocate General of State and determines his remunerations. The Advocate General holds office during the pleasure of the governor. Next, he appoints the State Election Commissioner and determines his conditions of service and tenure of office. However, State Election Commissioner can be removed only in like a manner and on the ground as the judge of the High Court. He appoints the chairman and the member of the State Public Service Commission. However, they can be removed only by the president, not by the governor. He can seek any information relating to administrations of the affairs of the state and proposals for legislations from the chief minister. Next, he can require the chief minister to submit for considerations of the council of minister any matter on which a decision has been taken by the minister but which has not been considered by the council. Next, he can recommend the impositions of the constitutional emergencies in a state to the president. During the period of president's rule in a state, the governor enjoys extensive executive power as an agent of the president. Last, he acts as a chancellor of university in the state. He also appoints the chancellor of university in the state. Now the next, legislative powers. The governor is an integral part of the state legislature. In that capacity, he has the following legislative powers and functions. Number one, he can summon or prorogue the state legislature and dissolve the state legislative assembly. He can address the state legislature at the commencement of the first session after each general election and the first session of each year. He can send message to the house or house of the state legislature with respect to a bill pending of the legislature or otherwise. He can appoint any member of the state legislative assembly to preside over its proceeding when the office of both the speaker and the deputy speaker falls vacant. Similarly, he can appoint any member of the state legislature council to preside over its proceedings when the office of the both chairman and the deputy chairman falls vacant. He nominates 1/6 of the member of the state legislature council from the amongst persons having special knowledge or practical experience in literature, science, art, cooperative movement and social service. He can nominate one member to the state legislature assembly from the Anglo-Indian community. He decides on the question of disqualifications of the members of the state legislature in consultations with the election commission. Next, when a bill is sent to the governor, after it is passed by the state legislature, he can give his assent to the bill, withhold his assent to the bill, return the bill, if it is not a money bill, for reconsideration of the state legislature. However, if the bill is passed again by the state legislature with or without amendment, the governor has to give his assent to the bill. Next, resolve the bill for the consideration of the president. In one case, such reservations is obligatory, that is, where the bill passed by the state legislature endangers the position of the state high court. In addition, the governor can also resolve the bill if it is of the following nature, that is, ultra vires, that is against the provision of the constitution. Second, opposed to the directive principle of state policy. Number 3, against the larger interests of the country. Number 4, of grave national importance. Number 5, dealing with compulsory acquisitions of the property under Article 31A of the Constitution. He can promulgate ordinance when the state legislature is not in session. The ordinance must be approved by the state legislature within the 6 weeks form re-assembly. He can also withdraw an ordinance anytime. That is the most important legislative power of the governor. He lays the reports of the State Finance Commission, the State Public Service Commissions, and the Comptroller General relating to the accounts of the state before the state legislature. Right, now let's discuss the financial power now. The financial power and the functions of the governor are, he sees that the annual financial statements, state budget, is laid down before the state legislature. Money bills can be introduced in the state legislature only with his prior recommendations. No demand for grant can be made except on his recommendations. He can make advances out of the contingency fund of a state to meet any foreseen expenditures. He constitutes a finance commissions after every 5 years to review the financial position of the panchayats and the municipalities. Now let's see the judicial powers. The judicial powers and the functions of the governors are: number 1, he can grant pardon, repriebes, respites and remissions of the punishments, or suspend, remit or commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. Next, he is consulted by the president while appointing the judges of the concerned state high court. Next, he makes appointments, postings and promotions of the state judges in the consultations with the state high court. Next, he also appoints person to the judicial service of the state other than district judges in consultations with the state high court and the state public service commission. Now we'll study in detail the 3 important powers of the governor: veto power, ordinance making power and the pardoning power, by comparing them with that of the president. Alright, so now let's discuss about the constitutional positions of the governor. The Constitution of India provides for the parliamentary form of government in the state as in the center. Consequently, the governor has been made only a nominal governor. He has been made only a nominal executive. The real executive constitutes the Council of Ministers headed by the Chief Minister. In other words, the governor has to exercise his power and the function with the aid and advice of the Council of Ministers headed by the Chief Minister, except in matter in which he is required to act in his discretion, that is without the advice of minister. In estimating the constitutional position of the governor, particular reference has to be made to the provisions of Article 154, 163 and 164. These are: number 1, executive powers of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution, Article 154. Next, there shall be a council of ministers with the chief minister as a head to aid and advise the governor to exercise of his functions, except in so far as he is required to exercise his function in his discretion, Article 163. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state, Article 165. This provision is the foundations of the parliamentary system of government in the states. So from the above, it is clear that the constitutional positions of the governor differs from that of the president in the following 2 respects. While the Constitution envisages the possibility of the governor acting at the time in his discretions, no possibility can be envisaged for the president. Number 2, after the 42nd Constitutional Amendment Act 1976, ministerial advice has been made binding on the president, but no such provisions has been made with respect to the governor. Constitution makes it clear that if any question arises whether the matter falls within the governor's discretions or not, the decisions of the governors is final, and the validity of anything done by him cannot be in question on the ground that he ought to or not to have acted in his discretions. The governor has constitutional discretion in the following cases: reservations of bill for the consideration of the president, recommendations of the impositions of the president rule in the state, while exercising his functions as the administrator as a adjoining union territory in case of additional charges. Next, determining the amount payable by the government of Assam, Meghalaya, Tripura, Mizoram to an autonomous tribal district councils as royalty acquiring from license for mineral explorations. Next, seeking informations from the chief minister with regard to the administrative and legislative matters of the state. In addition to the above constitutional discretions, that is, the express discretion mentioned in the constitution, governor, like the president, also has situational discretion, that is, hidden discretion derived from the exigencies of prevailing political situations in the following cases. Number one, appointment of the chief minister when no party has a clear-cut majority in the state legislative assembly, or when the chief minister in office dies suddenly and there is no obvious successor. Dismissal of the council of ministers when it cannot prove the confidence of the state legislative assembly. Next, dissolutions of the state legislative assembly if the council of ministers has lost its majority. Moreover, the governor has certain specified responsibility to discharge according to the discretion issued by the president. In this regard, the governor, though has to consult the council of ministers led by the chief minister, acts finally on his discretion. They are as follows: Maharashtra, establishment of separate development board of Vidarbha and Marathwada. And second, Gujarat, establishment of separate development boards for Saurashtra and Kutch. Number three, Nagaland, with respect to law and order in the state for so long as the internal disturbance in the Naga Hill Tunshang area continues. Number four, Assam, with respect to the administrations of the tribal areas. Next, Manipur, regarding the administrations of the hill areas in the states. 6. Sikkim, for peace and for ensuring social and economic advancements of the different sections of the population. 7th, Arunachal Pradesh, with respect to law and order in the state. 8th, Karnataka, establishment of a separate development board for Hyderabad, Karnataka region. Thus, the constitution has assigned a dual role to the office of the governor in the Indian federal system. He is a constitutional head of the state as well as the representative of the center, that is, president.